it doesn't take long for Lost Lake to get swollen and beat you up either.
You know, they haven't had a flood out there in a very long time, thank God. But.
Or get chopping.
Yeah, it gets choppy, it's very windy. I have to say that, I think it's because of the size of the lake, it's quite, I mean, we've seen it. Like a drone ocean.
Yeah.
It's just coming over our bulkhead.
I don't know if they're kind of recognize it. We need to get close to a little bit closer to what it's. I think, yeah.
And you know, these stuff all over that lake too, so
Oh, absolutely, yeah.
when the water is really high, you really don't see them. So. What was, sir? You guys
Judge, can you hear me? Judge. Let me go get Dyer because my picture, it was there a minute ago. Let me find out why. May I be excused for just a moment?
You may.
Okay. I gotta get my technical assistant.
Judge, we got the reports back on,
We're still gathering for it.
my apologies.
That's all right.
On Wilson, so
Okay.
so
Good.
we just got them, I think yesterday.
Gotta figure out where to draw the line.
They already did all that.
Oh, okay,
Yeah, she did all that.
good.
Said, hey, this is, so now we just gotta see if they'll have a meeting of the minds and agree.
I haven't agreed on much. Okay.
Judge.
All right. So do we have everybody we need?
Yes, Your Honor. Mr. Parsons, how are you doing? I don't think I've ever seen you in person. I'm not sure this still counts.
I'm doing well. How about you?
I'm okay. And I have my client here with me.
Okay. And is there just gonna be the one person testifying?
That's all I've got, yes.
Okay. And just want to make sure nobody wants a record.
No, we're fine with that one.
Yeah, I don't think a record's required, Your Honor. I think, typically the motion transfer venue hearing is just for argument only.
Okay. All right. Well, let me have your witness come in view and
Okay, scoot over.
there you go. Get you raise your right hand. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may proceed.
Mr. Parsons, you have the burden.
Right, Your Honor. As I stated, according to the rules of civil procedure, the hearing on a motion to transfer venue is typically for argument purposes only. I don't plan on asking any questions of the witness. That rule of civil procedure 15.064A states that the court will only consider, in considering a motion to transfer venue, will only consider the pleadings and affidavits on file. And so at this point, we filed our motion to transfer venue, noticed out the hearing. We specifically denied the venue facts that were initially alleged in the estate's application to probate, by specifically denying those facts. That shifts the burden to the plaintiff to file affidavits and discovery products to establish prima facie proof of venue facts that allow this court to maintain venue. The estate did not file a response until today. They filed it a couple hours before the hearing. I filed a motion to strike the response because Texas Rule of Civil Procedure 87.1 or 87.1 requires us to give 45 days notice, which we did. And then once notice is given, they're required to file their response along with any evidence supporting venue within 30 days or at least 30 days prior to the hearing. So that needed to have been filed back at the end of July, and it wasn't filed to today. So we filed a motion to strike their response. Regardless, with respect to the response, they did not provide the court with any evidence supporting the venue facts. The sole argument made in their response is that in our motion to transfer venue, we relied on States Code 33.102. And a court can, if a court does not have priority venue, they can transfer the proceeding. The estate has relied on 33.103, which deals with transfers for convenience. They state that 33.103 is only available for convenience of the estate. But 33.103 actually states the court may order that a probate proceeding be transferred to the proper court in another county if it appears to the court anytime before the proceeding is concluded that the transfer would be in the best interest of the estate, or if there's no administration of the estate. So that provision allows the court to transfer it for convenience, but it doesn't give it grounds to overrule a mandatory venue provision, the one that's stated in the Estates Code 33.001A1. So our position is that, we filed our motion to transfer venue. We specifically denied the venue facts. By specifically denying those, that shifts the burden to them to allege venue facts via affidavits or discovery products. They didn't file any of that. The response that they did file late doesn't provide any of that information. And also the argument made in that fails because that's not a provision that we're relying upon in requesting transfer of venue. The facts that were originally alleged by the estate, they did allege the decedent died in Amarillo, Texas, but then they rely on for venue stating that she was domiciled in Belleville, Texas, and had a fixed place of residence there. We filed an unsworn declaration in lieu of an affidavit on behalf of my client, Stephen Parker, alleging that she did not, in fact, have a domicile or fixed place of residence in Belleville, Texas. She had moved to Amarillo, Texas in in December of 2019. The Mr. Feeks had filed for divorce in February of 2020. Parties mediated and agreed to sell the house they claimed was her residence in December 2020. Before that was finalized, Ms. Feeks passed away. At the time that she died, once she moved to Amarillo in December 2019, she resided with her daughter and her son, my client, and went back and forth between Randall County and Deaf Smith County, which is a neighboring county of Randall County. When in August of 2020, she moved into a group home called Hidden Happiness, and that's located in Randall County, Texas. And from August 1st, 2020 until the time that she died, she resided, and she died in late January. She had resided at Hidden Happiness, which is in Randall County, Texas. So it's our position that her domicile and fixed place of residence at the time of her death was in Randall County, Texas. And that was all supported by the unsworn declaration of my client that we attached as an exhibit to our motion to transfer venue. So I think we've met our burden of challenging their venue facts and establishing venue in Randall County with respect to the probate proceeding. The way that I had filed this motion was basically a two-part motion. Although both proceedings are pending before this court, we have the probate proceeding, and then they filed a separate petition within as a related proceeding for a suit to recover estate property. And that's when I initially got involved in this matter. And with respect to that suit, they did not allege any venue facts in their petition. They only made the statement that, the probate's pending in this court, and so the related suit should also be pending in this court. But under the rules, any related proceeding has to establish and be analyzed under the rules that govern just general civil action. So you have to look to the Texas Rules of Civil Procedure for venue. You can't just file a related proceeding in in the same court as a probate proceeding. You have to establish independent venue. And so if you look at the general venue statute in Texas Rules of Civil Procedure 15.002A, the very first priority for venue is where a substantial part of the alleged events or omissions giving rise to the claims occurred. Those events or omissions occurred in Randall County. In the suit, they're seeking recovery of money that Mr. Feeks, following the divorce mediation, he paid money pursuant to the agreement reached in the divorce mediation. That money was received by Miss Feeks while she was residing in Randall County. The funds were then deposited into an account at a bank that's in Randall County. The bank that they're complaining about, the beneficiary designation, all of that was done and established in Randall County. With respect to that case, as far as convenience of the parties, witnesses about the circumstances surrounding the receipt of that money, deposit of that money, the opening of the account, the handling of the account, and Mrs. Feeks' competence at the time that all of that was done would be witnesses that are located in Randall County. So venue for that proceeding is also proper and is required in Randall County. There's no basis for it, and they haven't alleged a basis for it. They haven't, pled any venue facts or provided any venue facts via affidavit to the court to establish venue in Belleville or in Austin County. And so we filed our motions. We're asking the court to consider our motion and the unsworn declaration that we filed, and grant our motion to strike the response that was filed today by the estate. And we think that the information that we've provided in our motion to transfer venue and the facts that we've alleged established that venue should be in Randall County, and we asked the court to transfer the probate proceeding along with the related action pending to Randall County.
And Mr. Parsons, what do you see as being, left in the probate case, since the inventory's already been filed and approved? I realize there's this new lawsuit, but.
Right. Well, we have the lawsuit pending, and that was the main basis for this, for removing it, or for moving it up here, is the lawsuit. But in getting into it and looking at it, the determination was made that, the estate should have also been handled up here because this is where she resided when she died. In looking at the inventory, I think they still need to sell the house. But I think the main thing is resolving this lawsuit that's pending. And there's, like I said, venue on the lawsuit is independent of venue for the probate proceeding. And that's why I filed this, two-sided, motion to transfer venue. So, if the court were inclined, it could transfer solely the lawsuit and maintain venue of the probate proceeding. And really at this point, I know that the court had mentioned when we filed all this, I guess the court had looked at the file, realized that this had been pending for a significant amount of time. They hadn't filed the required inventory. Had mentioned that there's, potential for considering a motion or an application to remove the representative. That's a possibility of something that we may consider is moving to remove the representative. It's really the first order of business was to get the venue transfer issue determined and figure out where the rest of this is going to be pending.
Mr. Smith?
Your Honor, we did not have to make any response at all to this motion to transfer. And the documents that he has filed, one is not a verified pleading as required. The unsworn declaration does not support the venue transfer of venue. And they did not specifically attack the venue. The unsworn declaration and the pleadings themselves basically don't say that she ever had a fixed place of residence in Randall County. And the statute says if she didn't have a fixed place of residence, then it goes to where her the principal part of her estate, either where she died or where her estate, the principal part of her estate was. And the house was still she was still the owner of the house in Belleville, Texas. The fact that they had gone through a mediated settlement, it had not been completed. And so at the time of her death, she still owned the house. That's the bulk of her estate. The other part of her estate was oil properties that was down in South Texas. But this in and of itself says she lived sometime with Sabra, the daughter, sometime with Steve, and then she went into a nursing home. It doesn't ever say she established a new driver's license, a new voter registration, nothing that established that she was in fact establishing a residence in a nursing home. We're under we take the position that she didn't have the capacity at that point to do that. And so we believe that all of it should remain in Austin County.
And Mr. Parsons, any response?
Yes, Your Honor. With respect to the statement about the unsworn declaration, Texas Civil Practice and Remedies Code 132.001 states that an unsworn declaration may replace the requirement of a notary in a written sworn declaration, verification, certification, oath, or affidavit. So it has the same force and effect as if this was an affidavit or a verification. So his statement that our facts and our motion is not verified is inaccurate, because we can rely on that statute and use an unsworn declaration in lieu of an affidavit or verification sworn by a notary. And with respect to the argument that the house hadn't been sold yet, when you're looking at somebody's domicile or permanent residence, you have to look at the intent of that individual. And Ms. Feeks is no longer with us, so we can't ask her about her intent, but we can look at the circumstances that were going on at the time of her death. Mr. Feeks had filed for divorce. They had gone to mediation. They'd agreed to sell the house. She was living up here. She'd been in the same residence since August of that year. You can't sit there with a straight face and say that she intended to move back to 117 Douglas Drive in Belleville, Texas, whenever they were on the verge of finalizing a divorce, and that house was supposed to be sold as a result of it. Obviously her intent was to remain in Amarillo in Randall County, Texas, at the facility that she was residing at. So I don't think, and like I said earlier, I mean, when you're dealing with these motions to transfer venue, we challenged the venue facts. We asserted venue facts that support venue in Randall County. That shifts the burden to them to establish other venue facts that would allow this to remain in Austin County. And they didn't file anything or submit any affidavits supporting their venue facts. So they have not met their shifted burden to keep venue in Austin County.
Your Honor, may I respond?
You may.
I'm not trying to tell the court that an unsworn declaration can't be used in lieu of an affidavit. What I'm saying is the content of the affidavit, if what they're trying to prove is the intent of Mrs. Feeks, this doesn't prove the intent to establish a domicile. It said where she went, but that doesn't, there's nothing in here that you would normally see when you're trying to prove that somebody is living has established a residence in a particular place. Driver's license, voter registration, any social security, anything, none of it. It's a conclusion that she didn't have the intent to return. Now, I've been around a pretty good while. My beard's not gray because I'm new at it. And I've never seen anybody who wanted to make a nursing home their permanent residence. And that's what they're asking you to do, is that because she was put in a nursing home, that must reflect her intention to be a permanent resident of Randall County. And there's just nothing in here. In fact, to the contrary, she moved up there or was taken up there in December or in August, I believe.
Well, December of 19.
December of 19. And she moved in to the nursing home in August of 20. So she didn't establish a residence anywhere for 10 months. So we're saying that we didn't have to answer because they didn't shift the burden, because they have a conclusory affidavit that says what she intended, and they can't prove what she intended. So our facts stand.
And I'm looking at the inventory, and the biggest asset, of course, is the house. The value in the inventory is over 123,000, and that's the biggest asset in the estate. So motion to transfer will be denied. Anything else today?
Are you denying it with respect to both proceedings?
Yes.
Okay.
All right. Anything
Okay.
else
I
today?
would be excused then.
You may. Thank you.
Thank you.